What are the key estate planning documents every senior should have in place? Can a trust protect your assets? And when do you need one? How can you or your parents plan ahead for a future long-term care need? I'm Ethan Huizenga, attorney and owner of the Huizenga Law Firm PC, and this is the Siouxland Senior Planning Radio Show. Since I'm a lawyer, we've got to start by getting the fine print out of the way. Since legal advice is extremely personal, you shouldn't take anything said on this program as legal advice. After all, I haven't met you, and I don't know anything about you, your health, your family, your finances, your fears, or, most importantly, your hopes and dreams. Instead, my hope is that what you hear on this program will be educational and thought-provoking. Last week, in part 1 of our Estate Planning Essentials for Seniors series, we looked at the definition of estate planning. We described it as having 3 big parts. Number 1, estate planning means control while you're alive and well. That's control not just over your money, but also control over your well-being. Number 2, estate planning means taking care of yourself and your loved ones if you become incapacitated or disabled. Here too, this involves both taking care of your person and taking care of your finances. And finally, estate planning is about giving what you have to the people you want, when you want, the way you want. Then we went into the 4 main tools in an estate planner's toolbox. We talked about the last will and testament, financial and medical powers of attorney, and trusts. This week, we're going to take a deeper dive on the last will and testament. We'll review what a will is, then we'll discuss a bit about how a will works, and we'll conclude with one of the most common myths or misunderstandings we hear at the office involving wills and executors. First, let's look again at what a will is. A will is your final statement of what your wishes are for your property. It's the instructions you write down while you're alive, so your loved ones know what to do with your money and property after you die. It's one of the ways you can give what you have to the people you want. But your will doesn't really do anything while you're alive, and that presents some interesting practical challenges. Number 1, if you're dead, we can't ask you if the will represents your final wishes or if you considered certain facts or relationships. Number 2, how do we make sure the wishes you express in your will actually get followed? Since we can't ask if the will contains your final wishes, the process of creating a will is designed to ensure that the will is valid. For example, every will must be signed by both the testator, that's the person creating the will, and 2 separate witnesses. The witnesses can't be individuals listed in the will for any other purpose. If the will is valid, then we follow a process called probate to make sure that your wishes get followed and put in place. Probate is a court proceeding where a judge monitors the actions of your executor, or what we call a personal representative, as they make sure the executor treats everyone fairly who is entitled to a portion of your estate. So the executor administers the will through the probate process subject to court supervision, which ensures that your wishes get followed, but it only covers those items that are included in your probate estate. Let me explain. Even after you're dead, a will only handles the allocation of your money and property if you haven't made other arrangements for those things. The property that passes under the terms of your will is called your probate estate. Everything else is considered your non-probate estate or non-probate assets. For example, if I own a $100,000 life insurance policy on myself, I can set up beneficiaries on that policy to identify who should receive the proceeds when I die. If I list my wife as the beneficiary, she will get the $100,000 death benefit without those funds going through probate. Another good example of a non-probate asset occurs when a husband and wife own their home as joint tenants with full rights of survivorship. If the husband dies, the wife will continue to own the home on her own. This is a non-probate asset because the ownership changes from the joint tenancy to individual ownership by operation of law, not under the terms of the husband's will. For anything that doesn't have an ownership arrangement or a beneficiary designation that keeps it out of the probate process, the will controls how that asset is distributed at your death. In my house example, if the wife dies 3 years later and still owns that house, it will be distributed under the terms of her will and passes through probate to accomplish that. As the person who administers the will through the probate process, the executor has an important job, but their job doesn't start until the person who made the will dies, which is a good segue to our myth for this episode. Today's myth is that your executor is automatically in charge of the finances when you pass away. Instead, the person you choose as executor will have no access to your assets until they are officially appointed through the probate process. Your bank accounts are frozen by the bank until the executor can prove they have the authority to access and manage those accounts. If you're the executor for someone who has died, an attorney will be able to help you with the necessary documentation for this purpose. Even in this deeper dive on wills, we've really only scratched the surface of how you can utilize a will in your estate plan. We're going to move on to the financial power of attorney next time, but we'll keep talking about wills too. Do you know the difference between a will and a power of attorney? Tune in next week to find out. I always feel like it goes without saying, but please, please, please do not take legal action on your own because you heard it on this program. If you want to dig deeper on something you heard today, the Huizenga Law team would be happy to schedule a one-on-one vision meeting at our office in Orange City, where we can talk about your unique goals for your legacy. Just give us a call at 712-737-3885. You can learn more about elder law and estate planning issues on our website by visiting SiouxlandSeniorPlanning.com. And remember, it's not too late to protect everything you or your loved ones have worked so hard to build.